Welcome everyone to our monthly S&O IP webinar today. My name is Alison Statham. I'm the UK Client Director and I'll be your host today. I'm joined also by my colleague Sophia ZHANG from our Beijing office to talk about notable changes of examination standard for trademark non-use cancellation cases in China. Before we start though, if you have any questions during the webinar, please send them to me via my email. My address will be at the bottom of the next screen right now, and we will answer at the end of the presentation. So without further ado, Sophia.
Thank you, Alison, and hello, everyone. Yes, today we are going to cover 4 parts. First off, I will give you a general introduction on the trends of trademark applications in China. And then I will talk about the non-use cancellation procedures in China. I will tell you how things were done in the past and what has been going on recently. Now, let me share some figures about the trademark applications in China so you can better understand the situations here. In 2021, the number of trademark applications in China reached its peak, over 9 million. And moving on to 2022, there was a decline in the number of trademark applications, but the number still remained at a relevant high level of 7.2 million. And in 2023, the number basically maintained at 7 million. By September 15th, 2024, the valid trademark applications in China has reached about 47 million. That is a huge number. And let's go to this picture, and you can see the statistics shows that there are 66% of trademark applications in China are fully rejected, and about 11% are partially rejected. And there are only about 23% are preliminary approved. And this is due to the fact there are so many prior similar trademarks in China. Let's go to the page about the non-use cancellation. According to the trademark law, where the registered trademark has not been used for 3 consecutive years, without justifiable reasons, any entity or individual may apply to the trademark office for the cancellation of the registered trademark. So the aim for this non-use cancellation system is actually to encourage trademark owners to use their trademarks in a legal and effective way. And also, it can clear unused trademarks, stop people from registering trademarks in bad faith. And then it becomes a very commonly used method to clear prior trademark applications when people's new trademark applications are blocked. Okay, let's see how the practice in the past. In the past, it is quite easy to file a non-use cancellation case in China. The requirements are very low. First, the mark needs to be registered for over 3 years, and any entity, including individuals, can file such a cancellation. And the individual applicant allows filing a non-use cancellation application in the name of an unrelated individual without disclosing the actual applicant. And third, the applicant only needs to provide very, very minimum information to prove that the mark is not in use. And the fourth, the official fee for filing a non-use cancellation case is quite low. It's only about 56 euros. And the entire burden for proving use of the trademark is only registering. Failure to provide solid use evidence will lead to the cancellation of the mark. And the last, even the mark is maintained, the applicant can file an appeal against the decision. And in the appeal procedure, the burden for proving use is still on the registrant. Therefore, over the past few decades, non-use cancellation has consistently been a widely adopted approach for removing cited trademarks in the client's trademark applications. However, recently, the CNIPA has significantly changed its examination standard without any prior notice. And such a change has resulted in almost all recent non-use cancellation cases either being rejected or require supplementary submission. This not only affects the applicants, but also cause a very significant social impact. So the CNIPA officials explained this change is to regulate bad faith non-use cancellations. Consider the extremely low requirements and costs for filing a cancellation case in China. It has led to a significant number of bad faith cancellations. These cancellations go far beyond the scope of the dealing with the unused trademarks. They are using these procedures to make money or beat their competitors or something like that. So therefore, current requirements for filing non-use cancellation become much more higher. First, anonymous filing for non-use cancellation applications are no longer permitted. The true identity of the applicant must be disclosed, and the applicant and the IP agency shall submit a declaration to identify the actual applicant and disclose the applicant's own applications associated with the non-use cancellation case. And also, the applicant must conduct relevant detailed investigations against the target mark and its registrant, submitting investigation report. And also, the applicant and the IP agency shall commit not to conceal the actual cancellation applicant and other key facts from the CNIPA, and ensure the declared matters and provided materials are true, accurate, and complete. So, how to deal with such rejections or notifications of amendments? When we are facing to a rejection, we need to immediately refile the non-use cancellation in the name of the real applicant, and also doing investigations and submitting investigation report. And also it's important to make a supplementary submission for the related trademark refusal cases to require the examiners to suspend the examination. And when there is a notification of amendments, we need to follow the notice to carefully prepare the required materials. And if extra investigations are required, conduct investigations thoroughly, submit on-site investigation report if possible. Okay, let's go to the final page. Let's see the CNIPA's explanation about how to regulate bad faith non-use cancellation. What is bad faith? If the applicant has long and frequently filed non-use cancellation applications against different trademark owners, clearly beyond the reasonable scope of idle trademark clearance. And second, filing non-use cancellation applications for a trademark while clearly knowing that it has been used. For example, someone filed non-use cancellation against McDonald's, a hamburger. It is clear he is in bad faith. And also, if someone is filing non-use cancellation applications against the same trademark repetitively to increase the cost of the registrant to hold the trademark. And also, there are some other bad faith situations. However, please note that if the case is accepted by the CNIPA, the examination on non-use cancellation case shall remain unchanged like before. The trademark registrant still need to present solid evidence to show the use of the trademark during the required time period. Okay, that is all for today's information.
Thank you so much, Sophia, for this insightful presentation. Let me just quickly check to see if we've received any questions during this webinar. Yes, we have received a couple. The first is from a law firm, and the question is, we've heard that recently a large number of our clients have received notifications of amendment and rejection regarding non-use cancellation cases issued by the CNIPA. Is this really the case?
Yes, that is why we bring this topic for today's webinar. There are so many, I think about 90% of the non-use cancellation cases are objected by the CNIPA.
Thank you very much. And the next question is from a UK brand owner. What should we do in the first instance, and what proactive steps should we take to avoid this?
Well, I think first, before filing the trademark application, we need to do a trademark search to understand which marks may be our obstacles. And then if the client want to file non-use cancellations, we need to do investigation against the mark and the registrant in advance and make a thorough investigation report and submit the same to the CNIPA. And also, when we're filing the non-use cancellation, we must focus on actually the relevant goods. We should not file a cancellation to cover all the goods of the mark. We only need to focus on what goods are blocked for our goods.
Thank you, Sophia. And just time for one last one before we go. What types of evidence are now most effective in proving genuine use?
At present, investigation, on-site investigation, and also online investigation on all kinds of social medias to prove there is no information of the trademark or no information of the trademark on relevant goods, and submit all this information and the documents to the CNIPA.
Thanks so much, Sophia. So we have received a number of additional questions via email, which we haven't unfortunately been able to cover today. However, we will ensure that all of those questions will be answered separately after this webinar. The recording of this will also be made available, and details of which will be sent to you all shortly. So that just leaves me to say thank you very much for joining us today, and please get in touch if you have any further questions. Thank you.
Thank you.